for girls in California's secondary schools, how our schools are complying with Title IX. I'm going to ask your indulgence for a couple more minutes. We just finished session, and we'll have, I think, a few more of my colleagues showing up. Please note our newest colleague, Senator Wieckowski, is here in a timely fashion. That gives him a couple, bonus points. But for those of my colleagues who are planning to be here, I know there's a lot going on. I'm going to give us all maybe 3 or 4 more minutes before we start. So I want to first thank you all for being here. You see, it's amazing the magic of a chair. Well, maybe we can go ahead and start. So why don't we go ahead and do that since you're all here. And again, this is the time set for an informational hearing of the Senate Judiciary Committee with the Legislative Women's Caucus on attaining equal opportunity for girls in California's secondary schools and how our schools are complying with Title IX. Title IX has been, I think, one of the most significant civil rights for girls and women in our state and country. Actually, this is a federal legislation in the last 50 years. Granted, it occurred 42 years ago, but I know Title IX occurred before. I had the opportunity as an athlete to participate in school athletics. Girls in my day weren't even allowed to play Little League. But we have come a long way with the 37 words that really changed everything for young girls. No person in the United States, Title IX reads, shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. This measure was sponsored by Representative Patsy Mink of Hawaii. Many of us in this room, I know, remember her. And Senator Birch Bayh of Indiana. It was part of the 1972 Education Amendments and requires gender equity for boys and girls in every educational program that receives federal funding. Now, most people who know about Title IX think it only pertains to discrimination in sports, but athletics is actually only one of 10 key areas addressed by the law. Those areas include access to higher education, career education, education for pregnant and parenting students, employment, learning environment, math and science, sexual harassment, standardized testing, and technology. And since Title IX was passed some 42 years ago, it's been the subject of over 20 proposed amendments, reviews, Supreme Court cases, and other political actions. That's why we refer to it as a living and breathing document. Before Title IX passed, though, so you get a sense of how significant this has been, only 1 in every 27 girls played varsity high school sports. By 2001, it was 1 in every 2.5 girls, meaning that a total of 2.8 million girls played varsity sports in 2001, and it is my hope and indeed the fact that since girls' participation in 2013 to 2014 in high school sports nationally increased for the 25th consecutive year, setting an all-time record of 3.267 million young girls playing in high school sports. Boys' participation is still about 4.52 million, or about 1.2 million more. But when you think it was 1 in every 27, and now it's 1 in every 2 or 2.5, clearly Title IX has made its impact. Now, victims of sexual harassment in schools, another element of Title IX, and that includes harassment of boys, had no clearly established way to seek any kind of justice or financial settlements. Now, sex discrimination under Title IX includes sexual harassment by peers or school employees, and schools should now have policies about how to judiciously handle the situation, and we're seeing some progress, and we're going to hear more about that today. It's a challenging issue. We've had problems associated with college behaviors. We've had legislation to specifically address that. We wanted to bring that down to the high school level and have that conversation today as well. Now, it used to be that schools expelled pregnant students. Now, schools create separate programs for student parents, but the programs under Title IX are required to be comparable to a normal school curriculum, and enrollment in these alternative programs has to be voluntary, a real sea shift. And I think a critical one, as statistically we note that young girls who become pregnant and teen moms become more and more committed to getting their education so that they can provide for their families. Now, Title IX allows students to hold schools accountable for attaining equal opportunity. And while we've heard about this, I mentioned the Title IX complaints at the universities, we have been moving forward in that direction, particularly this past year, and universities hopefully now have gotten the clear message that they are going to be held accountable when they do not comply with Title IX. But as we talk with young people, it becomes clearer and clearer that we need to start addressing these issues earlier. And so today we're going to talk about it moving back or forward, depending upon your perspective, to the high school role and to see whether or not we are getting compliance, and then wanting to focus on hearing from both advocates and from the schools today. The fundamental principle that I think those of us on this dais do share, whether we are Republicans or Democrats, is that Title IX is an essential element to achieving equality. And I know that one of the areas where I've been privileged to find common ground with my colleagues on the other side of the aisle is that they too have daughters, many of them outstanding athletes, and people with great promise in other fields, science and math, and they want for their daughters what we all want, which is an opportunity for a level playing field and the opportunity to compete and succeed as well. So we are going to hear from advocates who are going to report on school compliance. We're going to hear from school representatives who are going to discuss from their perspective how they comply. We're going to focus on pregnant and parenting students, one of the elements of Title IX that is frequently ignored, sexual harassment, and the obstacles that these schools face in providing and complying with the law, including, as I mentioned, athletics. And we're going to hear also about innovative community efforts to help ensure compliance with Title IX. I did legislation last year calling on schools to identify the number of students at their school, how many are playing in sports, boys and girls, and things of that nature, with the hope that a lot of this compliance will be coming from students and their parents. We'll see if that works. That's certainly the goal, is that we can work together in a collaborative way to make this happen. So I want to ask you throughout these panels and members of our committee, the focus, I hope, will be on answering or beginning to answer some of the following questions. One is, aside from losing federal funding or being subject to a lawsuit, what enforcement mechanisms exist to incentivize schools to comply with Title IX? Two, how can schools achieve greater Title IX compliance? And three, what assistance do the schools need, and how could the legislature be of help? So again, we have seen tremendous strides, but we still do not have parity in Title IX compliance. We're going to work towards that. As I said, you know, the glass is half full, but we want to fill it up as much as we can. So those are going to be the questions. And before we get started, members, anyone like to make any brief opening remarks? Okay, you'll see the men in the room. They're very smart. They know we're in charge. All right, so let's turn to our first panel with representatives from the United States Department of Education's Office of Civil Rights, which is the primary compliance mechanism for Title IX, and the California Department of Education, here to provide us with a brief overview of both federal and state laws. Good afternoon. Please, if you take a seat, and we have the microphones. This is being televised as well, as if I understand correctly, and hopefully there'll be others who were not necessarily able to attend, but certainly would be interested in the subject and in the ways that we hope we can start addressing the problem and making progress. Good afternoon.
Good afternoon. I'd like to thank all of you for giving OCR the opportunity to participate in this important hearing. I'm Gail Sikowski. I'm the Chief Attorney in the San Francisco Office for Civil Rights. OCR is the agency within the U.S. Department of Education that's responsible for enforcing Title IX, as well as the other federal laws applying to schools and colleges that prohibit discrimination based on race and disability. Senator Jackson just gave a wonderful overview of Title IX, better than I'm sure I can do. Just to emphasize again, Title IX applies to all recipients of federal funds from the Department of Education. So that's all public schools, colleges, and universities, as well as most private universities and proprietary schools. As Senator Jackson pointed out, while there has been, since the passage of Title IX, a dramatic increase in opportunities for girls in education and athletics, there's still work to do, and the U.S. Department of Education, as well as the Assistant Secretary for Civil Rights, Catherine Lehman, remain strongly committed to vigorous enforcement of Title IX. What I'd like to do in my 10 minutes is give you a brief overview of OCR's complaint enforcement process, and then if I have a few minutes left to describe the major legal principles in each of the areas that you're going to be talking about today: athletics, sexual harassment, and pregnant and parenting teens. OCR, this is a little overview of the OCR process. OCR has 12 enforcement offices around the country. The San Francisco office covers all of California. That's the only state we cover. California keeps us, by itself, keeps us busy enough with complaints to occupy our time. OCR's work consists primarily of 3 types of enforcement activities. The majority of our work, excuse me, of course, today's the day I developed an allergy. Sorry. The majority of our work derives from complaints that are filed with OCR by parents or students or organizations who believe that there's been discrimination in an educational program based on sex. In addition, OCR conducts compliance reviews whereby the agency selects certain school districts or colleges for a review, possibly under Title IX or the other laws. And the compliance reviews give us an opportunity to examine issues that might not come up in the complaints. We also provide technical assistance to school districts and colleges to give them information to assist them in achieving compliance, and provide informational programs for parents and students as well. With respect to our complaint process, any individual or organization who believes that sex discrimination has occurred in the schools can file a complaint with OCR. There are no standing requirements, so any individual can file a complaint on behalf of anyone else. The person filing the complaint need not be the victim of the discrimination. Complaints can be filed through email, regular mail, fax, and we have an online process as well. Complaints must be filed within 180 days of the date of the discrimination, although we have discretion to extend that if there are appropriate circumstances. Another important principle in our process is that we keep the identity of complainants confidential to the maximum extent possible, except where necessary to complete the investigation or where required by federal or state law, such as the Freedom of Information Act. We receive about 1,000 complaints a year. I think last year it was 985. We investigate about a third of those, I would say. And of the complaints we investigate, about 50% are complaints alleging disability-based discrimination, about 25% are complaints alleging sex discrimination, and 25% are complaints alleging race discrimination. Those are very rough figures, but I think they'll give you an idea. The way our process works is the complaint comes into the office. We evaluate whether it states a claim. I'll limit my remarks to Title IX and not refer to the other laws, but we evaluate whether it states a claim under Title IX, and if it's within our jurisdiction, whether it's been filed in a timely manner within the 180 days. And if so, we send notification letters to the school district and to the complainant describing the allegations that we're going to be investigating. It's assigned to an investigation team. The process for investigation generally consists of sending the school district a data request where we collect documents. We don't have subpoena power, so this is voluntary, fairly voluntary. We collect all the documents that might be relevant to the allegations. We interview witnesses. We go on site and visit the schools if it's appropriate to that kind of case. In the event that we find a violation of Title IX, we offer the recipient an opportunity to voluntarily resolve the allegations. The vast majority of our complaints, I would say 99.9% of our complaints are resolved voluntarily with the school districts without the need for further enforcement efforts. After we notify the school district of our findings orally, and we send them a proposed resolution agreement. This is in the case that we make a violation finding. We send a proposed resolution agreement. We then discuss the resolution agreement, negotiate it with them, and ultimately come up with something that works for them and works for us. In that case, the case is closed, and we monitor the agreement to make sure the school district is implementing the agreement. So as I said, the vast majority of complaints are resolved voluntarily. School districts want to come into compliance generally after we point out any issues that they might have. I should say that we also have other options for resolution without findings. I won't go into the details because of the shortness of time, but OCR does offer school districts other options to voluntarily resolve a complaint without making findings under the law. It's only when we can't obtain voluntary compliance that we move to enforcement. As I said, it's very, very rare in my entire career of multiple decades with OCR. I've only been involved in 2 enforcement proceedings. The enforcement options are referring the case to the Department of Justice, where they can initiate litigation, or having OCR initiate an administrative hearing, wherein ultimately we would potentially have the authority to terminate federal funds. So I'd like to turn briefly in a couple of minutes to talk to you about the major Title IX compliance principles that are involved in the 3 areas that we're talking about today. In athletics, as Senator Jackson noted, the regulations prohibit discrimination in interscholastic or intramural sports at the K-12 level. If a district operates or sponsors athletics programs, it must provide equal athletic opportunity for both sexes. Right now, we currently have 4 elementary and secondary athletics investigations open in the San Francisco region, and we have 5 cases where we're monitoring the agreements. In determining school districts' compliance with Title IX, the issues generally fall into 2 major areas. I'm sure many of you are familiar with them. The first general area is whether the school district has effectively accommodated the interests and abilities of both sexes in its interscholastic athletics program. OCR has issued guidance in 1979 and then in 1996 describing the criteria that we use to determine whether interests and abilities have been effectively accommodated. And again, I won't go into detail right now because of the shortness of time, but would be happy to answer any questions. The second major area and in both of these areas, interest and abilities and benefits and services that I'll talk about, we receive complaints and we have initiated compliance reviews. So the second area, in addition to interests and abilities, are benefits and services that are provided to student athletes, and this might be in areas such as equipment and supplies, scheduling of games and practice times, the opportunity to receive coaching, the provision of locker rooms, medical and training facilities, and so forth. So examples of the kinds of complaints we get under this area would be that the girls' softball team is given less significant days of the week to play their games than the boys' baseball team. For example, the boys are given the days to play baseball when the school's most likely to get the most participants in the audience, whereas the girls get weekday nights, for example, as opposed to Friday and Saturday night. We might get a complaint alleging that the facilities for the girls' softball team, such as bleachers, PA systems, refreshment stands, it could be anything, are inferior to that of the boys' softball team. At the post-secondary level, we look at this whole list to determine compliance, and we balance the benefits in one area with the benefits in the other. At the secondary level, high school level, we do most of the time, and it's a little complicated to explain why, but we are able to look at isolated areas like facilities and so forth. Sexual harassment and assault. Pardon me, as you all know, there's been a dramatically increasing focus on the issue of sexual violence and sexual assault. OCR issued major guidance in this area long, long ago, in 1997, the sexual harassment guidance, which was revised in 2001. I'm very proud to have been one of the authors of that guidance, and I think it's remained, provided a good guide to the standards that we apply in enforcing Title IX. Also in April 2011, which you may be more familiar with, the Assistant Secretary issued what's called a Dear Colleague letter, where she laid out clarification of how OCR views sexual harassment and assault and how we interpret Title IX requirements. The majority of cases that we get in the area of sexual assault and harassment at the secondary level involve student-to-student harassment, a few cases of employees harassing or assaulting students. The vast majority involve an allegation of the failure of the school district to respond appropriately. Parents and students file complaints internally because we do require an internal Title IX complaint process. The Title IX regulations do require a complaint process, a prompt and equitable process. Parents and students that come to us have generally filed internal complaints and feel very dissatisfied for various reasons with either the outcome or the process that the school district has used. Interestingly, we're getting an increasing number of complaints based on gender discrimination, including discrimination based on gender identity, including transgender students. Of course, an issue that's also been in the public eye in California. As a general rule, we're looking, when we go into an investigation of a sexual harassment or a sexual assault complaint, we're looking at the sufficiency of the school district's response to the complaint. We're looking at policies and procedures. We're looking at how the investigations were conducted by the schools. We're looking at the standards that the school applied and how well trained the investigators and administrators were in dealing with these issues. The most common problems that we find at the elementary and secondary level, although they're getting better, are multiple procedures and policies that potentially are applicable to sexual harassment complaints. Frequently, there's a bullying policy, there's a sexual harassment policy, there's a uniform complaint procedure, and there's frequently a lot of confusion about which is the appropriate process to use when a student or parent has a sexual harassment complaint. I wanted to point out that in the last couple of months, the California School Boards Association has adopted a revised model uniform complaint procedure where we had input, the California Department of Education had input, and what we've tried to do is make sure that all of those required policies under state law work together more smoothly and effectively, so it's clear which process people should use. In addition to confusion over the processes, other common problems are a lack of recognition by administrators, a lack of ability by administrators to recognize sexual harassment cases as a civil rights issue as opposed to a general discipline issue in the schools, inadequate investigations that are not thorough, that are not documented, and where appropriate legal standards are not applied. And we also are receiving an increasing number of sexual harassment complaints involving charter schools. I do expect that OCR will continue to receive a lot of complaints involving sexual harassment and sexual assault, and the law will continue to develop in that area. Just briefly on pregnancy and parenting, as was pointed out, OCR's regulations specifically prohibit discrimination against a student based on pregnancy, termination of pregnancy, or recovery from any of these conditions. OCR receives, at least in the San Francisco office, I don't think this is true in other parts of the country, but OCR actually receives very few complaints alleging pregnancy discrimination. I would like to hope and think that that's because there's not much discrimination out there. Of course, it could be because parents and students are not familiar with their rights. In June 2013, OCR issued another Dear Colleague letter emphasizing that all of us need to do more to help young people who are parents stay in school and graduate. And OCR issued a document called Supporting the Academic Success of Pregnant and Parenting Students under Title IX. And our goal in issuing that document was to help secondary school administrators, teachers, counselors, parents in this important work to assist pregnant and parenting students complete their education and be able to move on successfully to colleges and careers. Also, we were given, Senator Jackson provided us some of these principles, but the main legal requirements with respect to pregnancy and parenting students under Title IX are, first of all, that it's illegal for students to exclude pregnant students from participating in any educational program, which used to be the case where students were not even allowed to participate in schools, including participation in special programs such as honors, interscholastic sports, and opportunities for student leadership.
So while you're taking that sip, could you wrap it up? I have been way too liberal in my...
I'm sorry.
It's all been, I think, very helpful having you here and talking about the perspective from OCR is very important because you're the main enforcement mechanism. But if you could just give us your best final pitch.
Good timing because I'm at the very end. So the other points involve if there are special programs for pregnant students, they have to be voluntary, and pregnancy has to be treated as other temporary medical conditions with respect to rights and responsibilities. I did want to wrap it up there because I wasn't sure whether you have questions now or whether we'll do that at the end. I apologize if I've gone over my time.
That's quite all right. And what I'd like to do is, when the panel is done, if there are any questions, feel free to ask them at that point in time. And now we have Monique Ramos, who is the Interim Director of the Government Affairs Division of the California Department of Education, which is the state entity that is tasked with implementing and enforcing Title IX provisions in state law.
Yes, for the K-12 system. And I just also want to point out, we're also in charge of monitoring for California's Sex Equity and Education Act, which is very similar in many respects to Title IX. So the department utilizes two monitoring tools when we go out and proactively monitor. And both of those tools overlap between Title IX and the Equity and Education Act. The first tool is referred to as the Education Equity Instrument, and it is done in conjunction with our federal monitoring office. So annually, the department selects 120 school sites to go out and monitor, and it's predominantly at this point for federal monitoring purposes. 40 of those school sites are then selected for the Education Equity Review. The department utilizes basically utilizes a selection process in which we're looking at a series of risks, including recent complaints that the department has received. The second tool is the Civil Rights Instrument, which also contains many components of Title IX, but many of the other types of complaints that were discussed. So that review is done separately from the Federal Monitoring Office. It is a different 40 schools that are selected for that review. And what we do is we look at enrollment demographics, local education agency sizes, as well as recent complaints. The Civil Rights Instrument is looking for proper notification, it's looking for signage, clear identification of who the Title IX coordinator is, and then an interview is conducted with that Title IX coordinator. We're looking to see their understanding of the law to ensure that they actually understand their responsibilities. We also interview impacted students to ensure that they know who that Title IX coordinator is and what their rights are for complaints. In addition, we look at the list of many other things that are covered under Title IX to ensure comparability. If a school is basically found out of compliance, there is a finding, and what happens is the department works with the school site to resolve that. A plan is developed, and then we work with them to implement that plan. The most common finding is either students not knowing who the Title IX coordinator is or not understanding their appeals process. So monitoring is our proactive way of ensuring that students are receiving their rights under Title IX, but our reactive way is basically what's referred to as the Uniform Complaint Program. This program utilizes several complaints from Title IX, also the Sex Equity and Education Act, and essentially every county office of education, school district, and charter school must utilize this process. So what happens is a student, for example, may complain about inadequate facilities for the locker room. They would first complain up to at the school site, so usually to the principal. If that, and then the principal is supposed to be investigating the complaint to determine if the complaint has standing. If the principal were to deny that complaint, the student has the ability to appeal up to usually the school district or governing board in cases of charters. Again, their job is to investigate and determine if there's a inadequacy there, and then the student could appeal all the way up to the California Department of Education, where we also do reviews and determine what basically the finding is. And oftentimes, especially for Title IX, I think we see, and we work closely with our friends at OCR, but they receive the bulk of those. What we are seeing a large amount of is new complaints related to the Sex, Equity, and Education Act, as well as the Safe Place to Learn Act. We've seen a lot of legislation in this area, particularly AB 9, related to harassment and bullying, and we've seen a huge uptick in relation to those. Lastly, just a couple other things the department has been working on. Last year, we sent a letter to local education agencies reminding them that they needed to have a Title IX coordinator and requesting information back as to who that coordinator was. The goal was to put together a statewide database. Unfortunately, we did not have a great response rate. Oftentimes when the department sends out surveys, we don't get great response rates. Schools are pretty busy. So we are attempting to go through and update that list with staff and make calls, but that takes quite a bit of time. Lastly, we are in the process of implementing CHAIR's SB 1349 and believe that it will be in the Civil Rights Instrument for the 2015-16 school year. Thank you.
Thank you. Are there any questions from the members?